Alberta Legislature for Tuesday, June 5th, 1990. I'm David Carter, Speaker of the House and member of the House for Calgary-Egmont. After question period today, the private members will be dealing with the motion number 211 as sponsored by the member for Edmonton-Calder, dealing with poverty of children and an attempt to eliminate hunger and poverty amongst young people and their families. Prior to that, however, the House will be dealing with written questions, motions for return related to a number of issues. This evening, when the House comes back, the business will be that of second readings of a variety of bills. At the moment, there are 13 bills at second reading stage, 15 awaiting committee of the whole. Third readings, there are 3 bills there, and 2 bills are awaiting royal assent. In addition to all that, 6 more government bills are awaiting introduction to the House. Let us pray. As Canadians and as Albertans, we give thanks for the precious gifts of freedom and peace which we enjoy. As members of this Legislative Assembly, we rededicate ourselves to the valued traditions of parliamentary democracy as a means of serving our province and our country. Amen.
Introduction of visitors.
The Associate Minister of Agriculture.
Mr. Speaker, it is my pleasure to introduce to you and through you to the Assembly members of a delegation from Indonesia. This delegation is on a familiarization tour of Canada and has had the opportunity to visit a great deal of our province in the last 2 days. Mr. Speaker, the delegation is seated in your gallery, and I would ask them to rise as I call their name and remain standing. The delegation is led by Governor Lamed Dijo, who is Governor of the province of Central Sulawesi. The Governor is accompanied by Mr. Sumarno, who is the Chief of Provincial Public Works, Mr. Mohad Sedin, Chief of the Provincial Business Council, and Mr. Tomi Talar, Chairman of the Consultant Association. Also traveling with the group is Mr. Bob Francis of Agri-Team Calgary. I would ask them all to rise and receive the very warm welcome of this legislature.
Honorable members, I would like to introduce to you the Senator of the House of the Speaker of the House of Representatives in the state of Alaska, seated in my gallery, Mr. Cotton. Please rise.
Presenting petitions. Reading and receiving petitions. Presenting reports by standing and special committees. Notices of motions. Introduction of bills.
Minister of Education.
Speaker, I take pleasure in introducing Bill number 48, an act to amend the School Act 1990. Mr. Speaker, the bill contains a number of small amendments that have come to light during the course of the last 18 months and the experience we've learned from administering and governing under the School Act 1988.
The Honourable Minister of Education has moved first reading of Bill 48, School Amendment Act 1990. Those in favor of first reading, please say aye. Aye. Opposed, please say no. Carried.
Bill number 48, School Amendment Act 1990, introduced by the Honourable Mr. Dinning, is now read a first time.
Member for Banff Cochrane, followed by member for Edmonton Meadowlark.
Thank you, Mr. Speaker. I'm pleased to request leave to introduce
Bill number 46, the Legal Profession Act. The intention of this bill, Mr. Speaker, is to update the Act and to make it more responsive to the demands of the 1990s. This will be accomplished by increasing the number of lay benchers, by specifying that disciplinary hearings are to be in public, unless otherwise directed by the benchers, and by increasing of monetary penalties for any member whose conduct is found to be deserving of sanction, and for any person or corporation practicing law in contravention of the Act.
The Honourable Member for Banff Cochrane has moved first reading to Bill 46, Legal Profession Act. Those members in favor of first reading, please say aye. Aye. Opposed, please say no. So ordered.
Bill number 46, Legal Profession Act, introduced by the Honourable Member Mr. Evans, is now read a first time.
Deputy Government House Leader.
Speaker, I move that Bill 46, the Legal Profession Act, be placed on the order paper under Government Bills and Orders.
Having heard the motion, those in favor, please say aye. Aye. Opposed, please say no. Carried. Member for Edmonton Meadowlark.
Thank you, Mr. Speaker. Mr. Speaker, I request leave to introduce Bill 261, being an act to phase out the use of chlorofluorocarbons. This act will have the effect of supplementing federal legislation in this important area. As we know, chlorofluorocarbons are responsible for the depletion of the ozone layer.
The Honourable Member for Edmonton Meadowlark has moved first reading to Bill 261, an act to phase out the use of chlorofluorocarbons. Those in favor of first reading, please say aye. Aye. Opposed, please say no. Carried.
Bill number 261, an act to phase out the use of chlorofluorocarbons, introduced by the Honourable Member Mr. Mitchell, is now read a first time. Tabling returns and reports.
Member for Edmonton Meadowlark.
Mr. Speaker, I would like to table a letter from Norman Dick, the Secretary-Treasurer, District 1, Region 8 of the National Farmers Union. This letter covers the resolution passed in April by the National Farmers Union Convention calling for measures to reduce carbon dioxide emissions. I should point out that this was the resolution that the Minister of Agriculture indicated he wasn't aware of.
Thank you, Honourable Member. Tabling is a tabling, not another opportunity to stand up and do a little conversation. Thank you.
Introduction of special guests.
Member for Athabasca Lac-La-Biche.
Mr. Speaker, it's a pleasure to introduce to you and through you to the members of the Legislative Assembly 92 students from the Athabasca Elementary School. They are accompanied by their teachers, Mr. Galanka, Mrs. Thompson, Mr. Lemesurier, Mrs. Belay, and their bus drivers, Diane Jewell and Harry Panelak. They are seated in the members and public gallery. And I would also like at this moment to special mention to a person that's really dear to me. That's my son Michael, that's traveling with a group. I would ask that they rise and receive the warm welcome of this assembly.
Ministerial statements. Oral question period.
Edmonton Highlands.
Mr. Speaker, Alberta Government Telephones is well known to be a very successful company, having invested about $1.6 billion just in the last 5 years in its expanded operations and enjoyed, believe it or not, a 6% increase in productivity every year for the last 17 years. On top of that, Mr. Speaker, as their audited financial statements prove, this company's a money-maker, consistently year after year, with only the occasional exception. Mr. Speaker, I know that the Conservatives are ideologically driven and they've got their minds made up and they don't want to be confused with the facts. But yesterday, the minister responsible, that is Minister for Technology, Research and Telecommunications, said, and I quote, "In fact, it," referring to AGT, "lost money 2 years ago for 2 years in a row," close quote.
Mr. Speaker, that flies in the face of the audited financial statements, which proves that this company's been making money hand over fist, actually, since 1983. My question to the provincial treasurer is this: does he concur in this minister's misstatement of these audited financial statements?
A mistake, Mr. Speaker. I did note that the minister made that statement. He is accurate. The company did lose money in 2 years, 1982 and 1983, and in fact has had thin earnings ever since then, based on the size of the entity. I'm sure, as all members know, when you cast your mind back at some times, you may have a difference in terms of the time, but the minister was accurate. The company did lose money in 2 years, and despite large earnings, in fact, had large revenues, had very thin earnings over the periods.
Well, Mr. Speaker, our experts, the ones we've consulted, say that AGT is doing almost as well as that great monopolist Bell Canada. In fact, less than 1% difference in the rate of profit during the last 5 years. So I'd like to ask the minister, or the provincial treasurer, if he's saying that the Minister for Technology, Research and Telecommunications was telling the truth when he said as recently as 2 years ago AGT was losing money. Will he now admit that that's not the truth?
No, as a matter of fact, the member draws attention to the annual statements, and since she's done that, I'll simply flip to the pages, and you will see that in the years 1982 and 1983, the company had losses in 1982 of $56 million on sales of $530 million, and in 1983 had losses of $21.674 million on revenue of 571, long-distance revenues, total revenues of 800. Speaker, I've said already that the minister, I'm sure, would have a chance to correct what he said himself, but the company did. Facts are here. The statement's been filed in the House. The company did lose money in 1982-83 for 2 years, and in 1987 it made about $19 million on over $1 billion worth of operating revenue. So, Mr. Speaker, the point is the company lost money those 2 years. It has not performed all that well, primarily because it's had a high debt servicing cost.
Well, Mr. Speaker, clearly the provincial treasurer is now participating in this propaganda campaign to make like AGT is a losing venture, but the facts speak volumes. They've made a couple of $100 million since 1983 during the recession. My question to the provincial treasurer is this: is he prepared now to admit that the problem with the financial statements has nothing to do with AGT's financial statements, but only to do with the financial problems that this particular treasurer has caused the province?
Mr. Speaker, I know the opposition would like to talk about some way in which privatization proceeds will assist us in the balanced budget, but we've already been through that debate in the House already, Mr. Speaker. We have shown that this government is on course to balanced budget without the privatization proceeds. The deficit has been reduced by $1 billion this year, Mr. Speaker, without any money from the privatization of assets, Mr. Speaker. And we have debated that already. It's in the budget speech going back to March. All members are well aware of it. All Albertans are well aware of it. But what is at point here, Mr. Speaker, is in fact that, as the member from Norwood or from Highlands did point out, there is a difference of view. Our view is that this company can be operated more efficiently, more profitably, and for better service to the consumer if it's in the hands of the private sector. And I don't think, Mr. Speaker, with respect, that Albertans are going to believe the kinds of nonsense they're hearing from the opposition. They know that these people have never been involved in business decisions. They don't understand how market forces operate. And I know that the proof here, Mr. Speaker, is going to be in response to the concept and response to the sale of shares, Mr. Speaker.
Government desperate measures, Mr. Speaker. Mr. Speaker, I'd like to designate the second question to the member for Edmonton Jasper Place.
Mr. Speaker, my question is for the Minister of Energy. Almost 3 months to the day from the date that the Natural Resources Conservation Board Act was promised in the throne speech to the date that it was tabled in the legislature, the minister said outside the House that this legislation was more talked about than any other that he could remember. And I happen to know he's been around a long time, so there must have been a lot of talk about this legislation. But I wonder if the minister would take the Assembly into his confidence to this extent, would he explain who the government consulted with during the 3 months and the period presumably prior to the throne speech when the government also thought about what it was announcing?
Mr. Speaker, he was, I understand his question, he was asking who consulted on the legislation. Is that the question? 59 MLAs, Mr. Speaker.
Mr. Speaker, they grow old together. They grow old. The Minister of Energy said at his news conference yesterday the Cabinet reserves the right to decide which of the projects going through the stream will be put before the NRCB and which ones won't. In the House yesterday, he indicated it would depend on how the Assembly dealt with the legislation, whether projects currently before the government will go before the board or not. In reality, the government alone decides when decisions are made about projects. I wonder if the Minister of Energy would take this opportunity to give us a straight answer to a straightforward question. Has the government decided it will not license the new Alpac project prior to hearings for the NRCB?
Well, Mr. Speaker, it was interesting to see the member for Jasper Place, the moment the table landed on his desk, rush out to get the media opportunity, make accusations that were totally false and erroneous about how the referral process is to the Natural Resources Conservation Board, comes in here and finally appears to have looked at the legislation and still is distorting it, Mr. Speaker. The fact is there is a mandatory list of referrals to the Natural Resources Conservation Board. Major water management projects, all forestry projects. Mr. Speaker, beyond that, if there is an environmental impact assessment ordered on any project, no matter what that project happens to be, whether it's recreation or tourism or whatever, if it is defined in the legislation and an environmental impact assessment is ordered, it is reviewed by the NRCB. In the event that the Lieutenant Governor and Council finds that there is some project that is not defined in the legislation and should be referred to the Natural Resources Conservation Board, notwithstanding an environmental impact assessment order, it will be reviewed.
Well, there were spurious and false allegations in the answer, but clearly not an answer to the question. The question being the Alpac proposal, which is currently before the government. Look, the government's been fiddling around with this legislation for 3 months. It's had the Alpac on its desk for 2 months, and now I'm asking the minister, has the government decided whether the Alpac proposal goes to the NRCB? See, here's your Alpac, here's your NRCB. Does the one go to the other?
He's something else, Mr. Speaker, let me tell you. Mr. Speaker, let me tell you and all honorable members of the Assembly that with regard to projects that are in progress, the decision has not been made as to whether or not they will be referred to the Natural Resources Conservation Board. That has got nothing to do with the legislation. The legislation before us is processed. We see today, Mr. Speaker, that he has read the legislation. He has no criticism of the legislation. He's now talking about process, and that's an endorsement of the legislation. Possibly, Mr. Speaker, they will refrain from holding up this masterpiece, this groundbreaking piece of legislation, historic on this continent, get it in place so we can start getting it active and start reviewing projects, Mr. Speaker, rather than hearing rhetoric from the member from Edmonton Jasper Place. I'm glad he's not my critic in the Department of Energy, Mr. Speaker, because I don't know if I could handle this guy much.
Edmonton Meadowlark.
Thank you, Mr. Speaker. Mr. Speaker, while the Natural Resources Conservation Board Act properly establishes a permanent board with the power to approve rather than simply to recommend, what is particularly disconcerting about this act is that it allows the government to curtail some of the boards, many of the boards, very, very important powers. To the Minister of Energy, since Section 22 of the Energy Resources Conservation Board Act empowers that board to investigate any energy project which it chooses to at its discretion, why is it that under this Natural Resources Conservation Board Act, that board must await on many significant projects the decision of this government to request an environmental impact assessment before the board can operate to do a review?
Mr. Speaker, the energy development, the development of our energy resources in this province are an integral part, whether it's from the licensing of the wells to the surface leasing, to the flow lines, to the pipelines, to the trunk lines, to the tying in of the wells. It is an integrated development of the resource. The Natural Resources Conservation Board deals with a range of renewable energy resources, Mr. Speaker, and even projects that are not in the sense natural resources. For instance, recreational projects, tourism projects. So it is not in the same sense a governance act. We have in the line departments, the Department of Environment and Department of Forestry, Lands and Wildlife, we have the line functions of licensing and permitting, and that will remain there. Mr. Speaker, we felt that we had to find a trigger mechanism that got projects that had an impact on the environment into the Natural Resources Conservation Board for review. That's why we had the triggering mechanism. We could have had the triggering mechanism of the cabinet making decision, of the board itself making the decision. We felt that that was too onerous and it was too broad. We want to deal with environmentally sensitive issues before the board. And that's the nature of the board and the purpose of the board. For them to be charged with the responsibility to look at all initiatives, whether it be a dump or whether it be a new subdivision or annexation, we felt that no, that was not appropriate. There are mechanisms in place to deal with that. So the environmental impact assessment triggering mechanism in the legislation with regard to the Department of the Environment is the trigger, Mr. Speaker, and we feel, we had a number of options, we felt that was the most appropriate.
The minister contradicts himself internally. It's just his answer isn't internally consistent. We don't have a triggering mechanism for certain forestry projects, but we need a triggering mechanism for other forestry projects. Mr. Speaker, my second question is to the Minister of Energy. Will the minister please confirm that this bill very carefully and very explicitly excludes forestry management agreements from review by the Natural Resources Conservation Board?
Mr. Speaker, with regard to the member for Meadowlark's preamble, forestry projects, as identified in the legislation, are automatically reviewed by the Natural Resources Conservation Board, whether or not there is an environmental impact assessment. That is clear and it is enshrined in the legislation. They will be reviewed. If there is a major forestry project in this province, if there is a minor forestry project in this province, and it is determined by Executive Council or Lieutenant Governor and Council that it should be reviewed, it can be reviewed. Outside of the definitions of the Act, we have that responsibility. That's a responsibility that government should assume and take. Now, Mr. Speaker, with regard to the second part of the question, I've forgotten. What is it? Forestry management agreements. Sorry, Mr. Speaker. The Minister of Forestry, Lands and Wildlife has been working on a forestry management agreement process, consultative process, and I'm sure that at an appropriate time he's going to be more than willing to share the details of that process with Assembly and with the public of Alberta.
Mr. Speaker, ALPAC, of course, is a major forestry project which the minister says will be reviewed automatically. Since ALPAC has not received its licenses, it would necessarily qualify for review under this Act. Will the minister please confirm that once this bill is passed in this legislature, in this session, that ALPAC by law must be reviewed by the NRCB unless this government is going to exercise its authority to define as reviewable or non-reviewable this particular project, the biggest fear for anybody who hopes for...
Member, thank you.
Mr. Speaker, the legislation per se, as written, is not retroactive. It comes into force and effect the moment it receives royal assent, and that is following the approval of this Assembly. With regard to projects that are in process at this particular time, they may be embarked on doing an environmental impact assessment. The policy as to whether or not those that are in progress are subject to the NRCB will be a decision made by a recommendation from ministers responsible to Cabinet with a decision made by caucus. I can't respond to that, Mr. Speaker. There will be a discussion about that. This is not retroactive legislation. The only way it can in fact be retroactive is if the government decides to refer the LPAC process or any other process to the NRCB. That decision is a policy decision, and it is not germane to the legislation.
Rocky Mountain House.
Thank you, Mr. Speaker. In this great province, we got many variances, not the least of which is the weather. Currently, we've got problems in some areas suffering from drought, other areas with too much moisture. There's an area in west central Alberta stretching from about Evansburg on down through Drayton Valley, Rocky Mountain House, and to the Dixon Dam, an area of about 20-30 miles wide that it's had a problem starting last summer with too much rain, then into the spring with a late damp spring, and now an early monsoon season. To the Minister of Agriculture, I'm wondering what the government's plans are for this situation, given that many farmers don't have any seed in the ground, the fields are covered with water, and it's now the 5th of June.
Good question. Mr. Speaker, the member is quite correct when he points out there are some areas in this province that are getting too much rain and there are others that are getting too little. And if I could just wave a wand and move that surplus rain from the west side of the province to the east side, we'd probably have everyone happy out there. But unfortunately, I can't wave that wand. My honorable member from Athabasca-Lac-La-Biche is talking about offering services in rain dancing, and maybe we're going to have to get him working on it. I should point out to the honorable member that it is only June the 5th. Normally we don't respond to the weather until we see what the outcome of a crop is. You will recall in the Northwestern Disaster Program we announced in February of 1990, addressing problems that occurred during the summer of 1989. The drought modification that we put into the recent Canada-Alberta payments is in recognition of consecutive droughts, the latest of which occurred in 1989. I should also point out, for the honorable member's sake and others that may be interested, that as far as the Alberta Hail and Crop Insurance Program component that pays out for unseeded acres, their cutoff date is June the 20th. So while I can appreciate the concern, it's something that we're going to have to watch unfold. Who knows, we may get a week of nice warm weather with some warm Chinooks that dries the land. We may get a late fall and a bumper crop out there.
Thank you, Mr. Speaker. Not only is it affecting the agricultural land, but many of the creeks and rivers have jumped their banks and are causing major amounts of damage. To the minister responsible for disaster services, what are your plans to help in this situation?
More money. Mr. Speaker, I'm certainly not going to take credit for disasters in the province of Alberta, but I will respond with respect to the matter. There's one river in particular in west central Alberta right now that is overflowing its banks, the Clearwater River. That's not a river that is unique in the sense that the flooding does occur. There has been some channel modification or channel revision by the way of nature in recent years in the Clearwater River. And it was several years ago that Alberta Environment had invested some public money in an attempt to improve channels in the Clearwater. I understand that yesterday the ravaging waters took out the channel improvements. Mr. Speaker, it's a matter that we'll have to assess as we go into the future, but it also points out a very important point as well, that nature is all-powerful.
Okay. Calgary Mountain View.
Thank you, Mr. Speaker. The government's been trying to convince Albertans that AGT must be sold in order to raise new and additional money for capital investment in the company. Let's make it absolutely clear, Mr. Speaker, that AGT is a sound company that has consistently paid its own way, unlike many of the private sector companies this government has been forced to bail out in recent years. AGT does have a high debt, including over $1 billion owed to the Heritage Savings Trust Fund, a debt that's come not from poor management, but because they've been directed to provide a high level of phone service to all Albertans. I'd like to ask the Provincial Treasurer, Mr. Speaker, given that the government estimates that its stock sell-off is expected to raise $1 billion, and that AGT will be required to pay off that debt to the trust fund, where is the money for new capital investment supposed to come from as a result of this share offering?
Well, Mr. Speaker, there are several hypothetical statements made by the member, and let me say two things. First of all, I don't think we have come to any conclusion as to what value will be attached to the company when we make the final prospectus available to Albertans to invest in this entity. And I don't want to pre-guess the value of the company. I can say, though, that there are two significant items here. First is that the General Revenue Fund actually owns the company and has the value of the retained earnings and the surplus profits in the entity. And as the member points out, the Heritage Savings Trust Fund, by appropriations approved by this Assembly, have advanced loans to AGT to assist in a normal course of operations, as opposed to having to go to the capital markets entirely. We have used the Heritage Fund to assist, and that has generated money back to the Heritage Fund, which I think all members probably would agree is appropriate. We have not come to any conclusion on the valuation, and why that's important, of course, is that if you haven't got an evaluation in mind and you haven't adjusted the so-called debt to equity ratios, which have to be done before the company can be privatized, we can't really answer specifically some of the hypothetical questions the member is suggesting. But we can say, though, that there'll be some benefits to the General Revenue Fund ultimately. There'll be some benefits to the Heritage Fund. And these, of course, are dependent on two things: the value of the company, the capitalization changes in the company, and finally the rate of sell-off of the entity based on the first opportunity or second or third opportunity. What will happen, though, Mr. Speaker, is when the company is recapitalized, when the debt that's in the company is switched to shares, there will be an internal operation efficiencies generated, and therefore the capital tests will be applied to a company with more earnings.
I can't believe it, Mr. Speaker. They've owned a company for 60 years and they don't know how much it's worth, and they're going to sell it when they don't know how much it's worth. I think the minister's answers are hypothetical, not the questions. The minister responsible for AGT has indicated that $230 million in retained earnings, which AGT presently holds, will have to be repaid to the government as a result of this sale. All we seem to be seeing is recycling new money for old money because of this privatization. I'd like to ask the Minister, if AGT is going to be forced to pay off $1.1 billion to the trust fund, $230 million to the Treasury, why bother privatizing AGT when it won't put any new money into the company as a result of that privatization?
Well, Mr. Speaker, you can see why these people have never been involved with risk-taking private sector activities or know nothing about business. I mean, all you have to do is take those few words and show them to anybody in the business sector, and they understand entirely why these group of people across here, with the exception of none of them, have ever been involved in the private sector. Now, they have been consistent to their socialist soul, I agree. They've never taken risk, never taken investment, and know nothing about the private sector activity, Mr. Speaker. And that's precisely why they don't understand the concept of this proposal. And that's why, Mr. Speaker, we think this is the best decision this government's made for some time. And we are very confident, Mr. Speaker, that the private sector response will be that the shares of this company will be bought by the investor in Alberta. They're going to have the first opportunity to invest their dollars, and this company will flourish in a new privatized, market-driven regime, Mr. Speaker.
Calgary Northwest.
Thank you, Mr. Speaker. Mr. Speaker, for quite some time the opposition has been trying to get a report commonly called the Alexander Report regarding the privatization of AGT. And unfortunately, we've always been unsuccessful because the government has always claimed that this is a sacred document and the information must remain confidential. The scuttlebutt in the financial industry, Mr. Speaker, is that RBC Dominion Securities Pemberton has been chosen as the lead underwriter for the initial AGT stock offering, and further that Mr. Keith Alexander, the person who prepared the report and who stepped aside in 1985 for the Premier to run in Edmonton Whitemud, is in fact currently the head of corporate finance for Dominion Securities. So my question to the provincial treasurer dealing with the selection of this is considering the ramifications of AGT and the privatization of AGT, Will the Treasurer now make that document available and table it in the House for all members to see?
Mr. Speaker, first of all, the member knows that the Assembly will be dealing with a motion for return, which is already on the, votes and procedures right now, which calls for a debate on whether or not that document will be provided. The Minister will be able to provide that information, Mr. Speaker, but it is a common rule within parliamentary systems, and including our own House, that internal documents used for decision-making purposes are essentially private, because when this information is provided, not only do the times change, the information changes, and the attitudes change. And so there's been a variety of other companies. I can say this, Mr. Speaker, that with respect to the way in which the sale of shares will take place, that there'll be a wide group of Canadian-based investment bankers involved, and along with the normal course of operation, one of them will be the lead underwriter, Mr. Speaker. I should also advise the Assembly and Albertans that to ensure that we had most objective possible advice, we have also hired an independent group of investment bankers who will not be involved at all with the share sale, who will provide to us independent view about the valuation, because the valuation is not a precise science and will be based on market responses and, I suppose, capitalization rates. We have retained an independent group to advise the government as well, because, of course, we want to have independent advice aside from the selling group.
My supplemental to the Minister, Mr. Speaker, is simply this. Does the Minister expect Albertans in this Assembly to believe that it's pure coincidence that RBC Dominion Securities is going to be given this license to make money with the AGT deal and the ties that this company has between Mr. Alexander and the Premier? Is that just a coincidence?
Mr. Speaker, that kind of misrepresentation is just that. The fact that RBC Dominion Securities is involved is not at all driven by who their key players are. It's based on their expertise, it's based on their professionalism, and it's based on their capability to handle this size of an issue. I make it very clear, Mr. Speaker, that there'll be a variety of groups involved in the selling side. And we're going to, as a matter of course, make it open to all Albertans to have access to these shares. And in fact, if you want to be able to access the shares, you can go to your local financial institution and buy the shares, Mr. Speaker. And so it isn't going to be driven by the control of one group in particular. It's going to be a very broad-based sale distribution, and there'll be a variety of companies involved in the general so-called banking group itself.
Calgary Foothills.
Thank you, Mr. Speaker. My question is to the Minister of Transportation and Utilities. I've had a number of calls in the last couple of days from owner-operators of large trucks that are haul outside of Alberta about the strike. In fact, in Calgary today, there are approximately 100 truckers that have voluntarily withdrawn their services. My question is, what does the Minister intend to do to get these trucks moving again?
Mr. Speaker, it should be pointed out that the best information we have at the moment is that the independent truckers in the province of Alberta are under contract to the companies that they work with, and that the dispute is between the independent trucker and the company and not between the government and the trucking companies or the independent truckers. It should also be noted that we understand that they're out in support of those trucks that are in dispute in British Columbia, two of which are independent truckers or union truckers that are working in the greater Vancouver area. So we do not intend, and we have not been asked at this particular point, to be a part of that.
Thank you, Mr. Speaker. Well, I guess before this gets out of hand, my question to the Minister is, have you been asked by the truckers to get involved, and are you prepared to possibly help name a mediator?
Well, as I said a moment ago, Mr. Speaker, we've not been asked, and I have had a number of calls from independent truckers asking what they should do, and I've indicated to them that as far as we're concerned, I'm not there to give them advice. They have a contract that they signed between the company that they're working for and themselves, and that if it's at issue, is between the two of them. But if someone was to ask, I assume the Minister of Labour would be the one to contact.
Stony Plain.
Mr. Speaker, as we all know, the sale of the Cormy Ranch and its potential billion-dollar development are being effectively blocked by the government's injunction against Mrs. Ivor Cormy. Yet, Mr. Speaker, the principal investor's lawyer, Mr. Bob White, has stated in court that he could not in good conscience trace the investor's claim to Mrs. Cormie's ranch property, which she bought in 1972, long before the principal collapse. And Dr. Ken Penfold, on behalf of the investors, advised us just this morning that it is their position that Mrs. Cormie be allowed to take her share of any sale proceeds. In short, Mr. Speaker, the investors want this sale to happen. To the provincial treasurer, given the investors' position that their interests will be best served by a sale of this land, would the treasurer agree to consider withdrawing the government's injunction against Mrs. Cormie?
Mr. Speaker, two things. First of all, this matter is not in the government's hands. This matter is, in fact, in the court's hands. The court is the final adjudicator as to what happens with the disposition of these proceeds. Now, Mr. Speaker, I have to be somewhat careful here, but on previous occasions I have read into the record excerpts from Mr. Justice Berger's decision, and I think it's public information, and he said, yes, we will hold these proceeds on a temporary basis, and secondly, should Mrs. Cormie desire to make an application to the court, he would hear it and may in fact agree that all or part of the proceeds could be paid to her. Speaker, I make the point very, very precisely that it's not the government that is any longer involved with this process. This process is now before the courts. It is now the courts that decide. It is not the government that decides.
Secondly, Minister, the questioner should have realized that it was sub judice. Let's have the supplementary. Let's see how creative you can be.
Mr. Speaker, I think that the skate around the pond is quite lengthy. I would wonder who put it before the courts in this particular instance, since the others claim they didn't. Mr. Speaker, it's not only the investors who want this sale to go on. The councils of Parkland, of City of Edmonton, they've expressed their desire to see this sale go and the development proceed. Mr. Speaker, this is because the economic boon to the province in the form of taxes, tourism, and jobs from the proposed billion-dollar development will be just tremendous. Now, given that the citizens of Parkland, of Edmonton, of Alberta in general, and I'll try to phrase this so it doesn't hit the sub judice rule, could the treasurer please explain to this assembly his reasons for continually depriving Albertans of the benefits of a potentially billion-dollar investment?
Mr. Speaker, that's just wrong, absolutely wrong, and we know, and now everybody knows the process here, Mr. Speaker. First of all, we have heard all members along the caucus members and cabinet ministers explaining and expressing their view that this project is a valuable project for Albertans, is one that the government would like to see proceed through the various approval processes, including municipal approvals. And we have done everything here, Mr. Speaker, to ensure that the process itself is opened, and so that the process can start, including, for example, the assurance that the order in council proceeded to allow the foreign ownership of land to transfer, Mr. Speaker, which is a very significant step on our behalf. Second, in terms of facts, Mr. Speaker, remember that the code report, which these people across the way called for time and time again, said that there was, Mr. Speaker, and I haven't got the direct quote here, but Mrs. Cormie, in fact, was named in the code report. So I have to say that that, as a matter of record, is there. Thirdly, Mr. Speaker, members of the opposition, including the leader of the opposition party, was up saying that was the appropriate thing to do, and we should, in fact, ensure that the court process was the one that adjudicated the outcome of this event, and that, in fact, is the case. And finally, Mr. Speaker, as I have said before and read into the record, is a letter from this Penfold gentleman on May 22nd, 1990, where he says, and I quote again, "We, the investor, must stand up for our legal rights if the end result is that Cormie scuttles proposed sale of his ranch to the Japanese. That's his problem." I should point out, Mr. Speaker, that in fact, the province does not have any legal claim to the land. We cannot make up our minds for the owners of that property. It is entirely in their hands, entirely in their hands. They are the ones who have to make that agreement. Now, Mr. Cormie, Mr. Speaker, has entered into a consent agreement with respect to the proceeds. I must agree, therefore, that he's going to sell it. I have no other information with respect to this matter, and if necessary, I'd be glad to file for the member Mr. Penfold's comments, because it's very clear that he's on exactly the same point as the government is.
Agreed. Edmonton Avonmore.
Thank you, Mr. Speaker. My questions are to the Solicitor General. Mr. Speaker, it has been recently reported that 2 Edmonton doctors and 7 doctors in Calgary will soon stop performing abortions for Alberta women because they fear the fear of legal harassment made possible by the recent federal Conservatives' new abortion law. The Attorney General has already told us that his department will be adopting a careful policy of restraint to discourage frivolous use of the courts by those who would take away reproductive choice from women. In view of the fact that, like prosecutors, police may also be used to harass doctors by being required to investigate frivolous complaints by these same people, will the Solicitor General also be taking steps to prevent the province's police force from becoming unwitting tools in any campaign to harass doctors by the anti-choice movement? And if so, what are they?
Mr. Chairman, Mr. Speaker, it's not the intention of the Solicitor General's Department to be taking any action whatsoever in respect to the police forces of this province as it may relate to abortion problems or non-problems. And I say that the actual operation of police forces, with the exception of the RCMP, is under the total jurisdiction of the police commissions that are in charge of the police forces. And in respect to the RCMP, it is from K Division headquarters on which they receive their instructions. But I don't think it's fair at all, Mr. Speaker, to suggest that there are any circumstances that exist or may exist in which the police forces of this province, either the RCMP or municipal, will harass any doctors at all in this matter.
Well, Mr. Speaker, the investigation of a frivolous complaint may in and of itself be harassment. My second question is to the Minister of Health. The Minister of Health has said that everything is fine for Alberta women right now, but the reality is otherwise. The fact is that doctors are beginning to stop performing this service, which has always been difficult to obtain in Alberta. What is the Minister going to do about the ever-increasing difficulty of obtaining abortions in this province, which is recognized as a health...
Thank you very much.
Mr. Speaker, I don't want to have the record show that I've said that everything is fine with Alberta women. I think there's lots of issues that we need to deal with, and we're dealing with them. As I've indicated in the Assembly previously, I believe that access to this medical procedure can and should be met within the existing hospital system. And I would be surprised, and frankly, I would be disappointed, Mr. Speaker, if physicians would refuse to perform a medical procedure for fear of some proposed federal legislation that is probably several months from final consideration, and I'm not prepared to prejudge the outcome of that process.
Edmonton Whiteman.
Thank you, Mr. Speaker. Mr. Speaker, needless to say, I am not what you would call overly confident with the handling of lottery funds for the minister responsible for those funds. I have raised questionable spending in the past, and I'm still not satisfied that additional dollars are not being funneled from lottery funds for what I call self-interest purposes or for political gain. Now, from the annual report produced by the Wild Rose Foundation, and this question, Mr. Speaker, is to the minister responsible for lotteries, will the minister explain why the administration cost per application for applications received by the Wild Rose Foundation has increased from $747.88 each to $1,930.50 apiece, or an increase of 158.13% for the period of 1986 to 1989. In other words, a 3-year period.
Mr. Speaker, the annual report, the 5th annual report to the Wild Rose Foundation was tabled in the House several months ago. And in the annual report, we'll find a coverage of all of the grants that have been approved in the fiscal year from April 1, 1988 through to March 31, 1989. And the honourable member will also note in reading the report that, in fact, even though the province of Alberta provided to the Wild Rose Foundation a figure of $5 million for dealing with all the applications that the Wild Rose Foundation would deal with, the member would know that in the fiscal year from April 1, 1988 through to March 31, 1989, that there were a fewer number of projects that were dealt with and approved in that fiscal year as there were in the previous fiscal year. And yet the modest amount of dollars that have been allocated and utilized by the Wild Rose Foundation for administration essentially remain the same. So if one were to divide the number of projects, as I presume this is what the honourable member from Edmonton Whitemud has done, divide the number of projects that were approved in one fiscal year as compared to the number of projects that were approved in the previous fiscal year, and the administration costs remained essentially the same, then in essence he would see an increase in per application, I suspect, with that. There's a very important reason, Mr. Speaker, as well, while the Board of Directors, which were appointed at large from throughout the province of Alberta, did not utilize all $5 million because the government asked them to show fiscal responsibility. And it's not the job of the Wild Rose Foundation to throw away money willy-nilly everywhere, but, Mr. Speaker, but to deal with those needed projects. And I have publicly in the past congratulated the Board of Directors of the Wild Rose Foundation for showing fiscal responsibility. And I would want to do that again in the Legislative Assembly today, Mr. Speaker.
My supplementary, Mr. Speaker, to the minister responsible, obviously he hasn't looked very thoroughly at the annual report because he would see that the administrative costs increased by 116% in that time frame, yet the amounts given out in grants was basically the same. The number of applications was actually reduced. But could the minister, Mr. Speaker, through you, could the minister explain why travel costs went up 494.15% in the same 3-year time period?
Mr. Speaker, one of the important objectives of our government is to basically take government to the people in the province of Alberta. Mr. Speaker. Mr. Speaker, this government does not believe that there is only one municipality that exists in the province of Alberta. This government believes that there are 328 municipalities that exist throughout this province, and we do not believe that everyone in Alberta must come to Edmonton to get a decision, Mr. Speaker. Mr. Speaker, we believe in taking decision makers out of Edmonton and having them visit the various parts of the province of Alberta. Doing so, Mr. Speaker, we also recognize that these are volunteers and their travel time and the cost of their meals and the cost of the hotel rooms must be borne by the citizen at large. We do not ask volunteers to pay for this out of their own purse. So needless to say, Mr. Speaker, if you want to follow the principle that the Wild Rose Foundation should have a meeting in Whitecourt or in Red Deer or in Grand Prairie or in Fox Creek, that it costs a few dollars to deal with that, Mr. Speaker.
Thank you. Calgary Bowl. Calgary Bowl.
Mr. Speaker. Mr. Speaker, my question is to the Minister of Culture and Multiculturalism. Mr. Minister, there are media reports today that the Provincial Museum has broken the American laws by importing Native artifacts to Canada and also has not informed the Native leaders of this action. Could you explain why the Provincial Museum would do such a thing?
Mr. Speaker, there has been, I guess, over the past many years, efforts by the Provincial Museum and other officials of government to ensure careful preservation of Native heritage and culture material. The museum is going to continue to do that, and I guess one of the biggest aspects of our efforts to do this is Head Smashed in Buffalo Jump near Fort Macleod in the southern part of the province. Mr. Speaker, some number of months ago, as a matter of fact, something in the order of 2 years ago, a gentleman in Browning, Montana, decided that he would sell a collection of Blackfoot material that he had amassed over a period of time. And the Provincial Museum officials became aware of this and began a discussion with Mr. Scriver. There was a danger at the time that this material, very important to understanding Native history, might fall into hands of investors offshore in foreign lands and would be lost forever. But the Provincial Museum, working very closely with the federal government, with the government of the United States, fully aware of what was going on, managed to acquire this most valuable collection. It's now housed in the Provincial Museum of Alberta here in Edmonton. It's going to be open to the public in just a couple of days, and it provides an opportunity for all Albertans to learn and to share in this most precious resource.
Thank you, Mr. Speaker. Mr. Minister, some Native people say that the government, through the museum, is actually denying them access to this material which is so important to their cultural and history. Is this in fact true?
Mr. Speaker, I've heard the suggestion made, and it's made by some people, that by having a museum acquire this type of material, that we are denying access to important spiritual, historical, and cultural material previously in the hands of natives. And, Mr. Speaker, in fact, the case is exactly the opposite. When material such as this is lost, for example, to an offshore investor, if it's held in private hands, in a private collection, even onshore, that material is inaccessible. Nobody can touch it or see it other than the private owner. When it's in the hands of a public trustee, such as the Museum of Alberta, all people, everyone, has an opportunity to study, to learn, and to regard this material in a very close fashion. We work very, very closely with Native elders, with chiefs, with bands, and we have made the commitment to them. As a matter of fact, we are closely involved with them in bringing the material here. We've made the commitment to them that at any time it's accessible in the museum, and given the proper conditions of environment and security, the material can even be removed from the museum on a loan basis.
Minister of Energy, followed by Westlock Sturgeon, then the Minister of Energy, then we go to a point of privilege.
Mr. Speaker, yesterday, June 4th, the member for Westlock Sturgeon asked a question with regard to irrigation and electricity. Mr. Speaker, there was two parts to the question. I can answer the second part, but maybe the member would like to clarify the first part. The first part being reference to a misunderstanding on a subsidy, is something with reference to $20,000 to $50,000 paid by farmers for irrigation facilities. I cannot find anywhere a subsidy for irrigation farmers for electricity rates, Mr. Speaker, and maybe he could clarify that at some point. To answer the second point of his question, he was asking about rates per se, and the honourable member should know that irrigation customers only pay about 70% of the cost of service. Across Canada, there has been a movement by public utilities boards to move to a one-to-one, closer to a one-to-one ratio in terms of cost and utilization, a move to full cost recovery to the fullest extent possible. And TransAlta has filed to move the irrigation rates to about 90% of the costs, which would cause about an 8% increase. I should let the honourable member know that the Public Utilities Board has slotted on June 11th of this year to separately review the irrigation rate issue at a public hearing, and that will be held at the Energy Resources Conservation Board building in Calgary at 11 o'clock.
Mr. Speaker, I'd like to thank the Minister for such a prompt answer. I've waited up to a year for the Minister of Agriculture and still got nothing, but so thank you. Thank you for the promptness. To go on for a further supplemental, you did mention a subsidy when you said 70% and was moving to 100%. It's at 30% that the farmers are worried about, Mr. Speaker, because they use power when the lower power consumption is low in the summer months. So therefore, they think the cross-subsidization should continue because of the fact they have spent $50,000 to $60,000 in capital costs, now trapped with using electricity. And now the government is not fighting their cause to keep the subsidy or the rate at 70/30.
Yeah, the Public Utilities Board, of course, has quasi-judicial powers in this connection, and as I've indicated, are going to be hearing the irrigation rates as a separate issue. This is a matter of rate design, which is the jurisdiction of the Public Utilities Board, as is their intention to move to a full cost recovery service. That is, that the users cover the cost of the facilities and the commodity that is being delivered to them. However, we can argue in this assembly until we're both blue in the face. The matter will be determined by the Public Utilities Board, and I encourage the member for Westlock Sturgeon and other members in the assembly who have irrigation farmer interests to refer them to the June 11th meeting in Calgary at 11 o'clock.
And before we proceed, might we have unanimous consent to revert briefly to the introduction of special guests? Opposed? Carried. Thank you. Minister of Public Works, Supply and Services.
Thank you very much, Mr. Speaker, and to all members of the Legislative Assembly. In the members' gallery today are a number of young people from J.R. Harris Junior High School, and accompanied with them are teachers Pam Conenbelt and Patty Schultz, and another distinguished gentleman in the community, Mr. Rod Sturwell. Our friends are in the members' gallery. I would ask them to rise, and I'd ask all of my colleagues to extend them the warm wishes.
Reported point of privilege, member for Edmonton Jasper Place.
Thank you, Mr. Speaker. As all members know, the privileges of this assembly are generally concerned with our ability as members to do the things that we're elected to do. And not least of those, of course, is to debate legislation before this assembly. Last Friday, June the 1st, I attempted to debate second reading of Bill 22, the Livestock, 31, the Livestock Diversification Act, during which time I was interrupted not once or twice, 4 or 5, but 8 times by various members of the government on so-called points of order. But 2 of those interjections have caused me a great deal of concern, and I would like to deal with them in the context of privilege. Both were by the Minister for Economic Development and Trade. The first at page 1588, where he states, may I ask him, referring to myself, if he would be honest and tell the truth as to what he has said to game farmers that have called him because it is contrary to what he's saying in this House today. And not satisfied to do it the once, he went on page 1590 to say that he would ask the honourable member if he did have conversations with those involved in game farming, because I just want to have the honourable member put on record a clarification of what was conveyed to me by individuals who had talked to him. Now, there is a possibility that this whole matter revolves around a dispute as to a matter of facts, although it's difficult for anybody to tell that because the minister put forward no facts whatsoever in relation to those suggestions and allegations, not a name, no reference to what comment he was referring to that I was alleged to have made. Now, one of the functions of the chair in relation to this matter is, according to Beauchesne 486, to determine whether the words are meant to be applied to public conduct or private character. There's nothing on the public record that indicates anything to do with public conduct. If perhaps at one point the minister referred to private phone calls. Now, I have no idea what access he might have to my private phone calls, but there's absolutely nothing in relation to the parliamentary authorities that I can find that entitled the minister to delve into my private phone calls, except perhaps in the event of insurrection or war, which doesn't apply here, notwithstanding the citation that was suggested. Chapter 6 of Erskine May and many other references deal with freedom of speech in Parliament. It has been suggested that offering to contradict a member from the gallery might be considered a contempt, or challenging the motives or veracity of a member has also been put forward as contempt. Now, if this is a question of resolution of fact, I think we can resolve that, but if not, perhaps the government feels it's been influenced to table legislation based on a false report of a position that I was going to take in the Assembly, in which case that may be a more difficult problem. However, I feel my privileges may have been violated, and if the chair agrees I have a motion I'm prepared to put forward.
Minister of Economic Development and Trade.
I appreciate the opportunity to deal with this issue, and I thank the honourable member for raising it because it is a very serious issue. If one will read Hansard, and let me first deal with, I pointed it out under a separate point of order, my error when I referred to the war and insurrection. It was 5th edition rather than 6th edition, and I'm sorry I erred there. But I wanted to give the honourable member an opportunity to clarify what an individual had indicated to me, and that was the reason I raised it. If the honourable member is sensitive as to his position on this matter, I regret that is so, because I should indicate to the honourable member, and I take it very seriously because he is suggesting that my comments were completely false. And I'm going to, and if you'll allow me, sir, I want to deal with a couple of issues that he related in his speech, that if I wish to, I could indicate they are dishonest or not the truth but I'm not allowed to say that, so I will just say the honourable member is ignorant of the facts. Because if he looks at his own speech on page 1589, he goes through a list of provinces that do not allow the sale of elk meat, and he puts it on public record. Well, I wish to table with the Assembly the dispute of the facts conveyed. What I'm pointing out to him is the inaccuracy which he consistently deals in, as he is doing with this question of privilege. Right. And I'm using this to substantiate it, Mr. Speaker, because he goes through, and I will file it with the clerk of the House, he goes through saying that British Columbia does not allow the sale of elk meat.
Got a point of order. Sit down.
I listened very patiently to the honourable member a moment ago. I wish he'd extend the same courtesy.
Thank you, honourable members. Let's get this straight. We're not going to have people all standing up at the same time. The chair's made note there will be a point of order in a moment, but in the meantime, the member is still responding to the purported point of privilege. And the chair will not be shouted down by any member in this House.
Mr. Speaker, I re-emphasize what I indicated earlier. It is a serious issue. And if the honourable member wishes me not to raise the issue in future, whereby I ask simply for a clarification as to the position as it relates to the individual, because I share with him a game farmer, not my cousin, so it is put on record so that the individuals opposite cannot continuously indicate that we have a conflict of interest, but it was not my cousin, for the record, an individual who is a game farmer who indicated he had talked to the honourable member and said that he had some sympathies towards his position. All I asked for, if the honourable member, and he was kind enough to refer to the quotation in Hansard, and I will reinforce the quotation that he indicated on page 1590, when I indicated to him, because I just want to have the honourable member put on the record clarification as to what was conveyed to me by individuals who had talked to him. If that's too much to ask in the course of the debate, to allow the honourable member an opportunity to place the truth on the record, contrary to what he put on the record on page 1589 that I just referred to, whereby I will simply say the honourable member was ignorant of the facts rather than attempting to mislead the House.
Right. The point of order will be dealt with in a moment. We're dealing with a matter of privilege. And the chair is somewhat bemused, I suppose is the word, for the sensitivity of some members who themselves on various occasions are given to hyperbole in debate. The chair also has looked at the matter and listened, and with respect to the pages of Hansard as quoted by the member for Edmonton Jasper Place, 1588 as well as 1590, the comments really are challenges made with respect to other comments which may or may not have taken place outside of the House. Indeed, from Beauchesne, 31, subsection 1 and subsection 3 are relevant. Subsection 1, a dispute arising between two members as to allegations of facts does not fulfill the conditions of parliamentary privilege. And again, subsection 3, statements made outside the House by a member may not be used as the basis for a question of privilege. Therefore, there is no, this matter fails the test of being regarded as a prima facie case of privilege. Now let's deal with the point of order, Edmonton Jasper Place.
The point of order, I got up on a question of privilege relating to the statement by the member that what I had said to game farmers is contrary to what I'm saying in the House. I mean, that's what he said. It wasn't a question. It was a bald statement. And I said if it's going to become a question of facts, he has to provide a fact, some fact, like something that was said and somebody to whom it was said. But as it is now, it's a smear. It's just kind of a broad brush approach saying something was said to somebody which is contrary to something else that was said in the House. You know, take it as you will. But my point of order is, under the guise of that question of privilege, the minister got up to debate the bill, and that's the question. That's the point of order.
Okay. There's no point of order. Thank you. Orders of the day.
Written questions.